Hello and welcome everyone to this NQA webinar. Does ISO 27001 cover the requirements of the GDPR? We'll just hang on a few more seconds just so everyone can attend. Like I said, this is the third iteration of this webinar. For those of you who sat through previous versions, you'll notice it's this version is similar to the others, but we've updated it with more relevant information that's come out. So hopefully you'll get something out of that. So the webinar, the slides will all be available to everyone afterwards. So you will be able to view the recorded version of this webinar on YouTube, on our YouTube channel, and you also get a link sent out to you via email as well. Questions, as always, please feel free to ask any questions using the question bar at the side, and also as well, if someone can just ping me a little message just to say you can hear me okay, or whether I need to turn up my volume, that'd be great. So if someone could just give me a quick nod to say you can hear me okay. Brilliant. Thank you, Samba. Thanks for that. Okay, yeah, we're getting quite a few through now saying that they can hear me. Good. That's always good to know. Thank you very much. Yeah, I think the consensus is we can all hear me okay. Okay, brilliant. Well, we shall make a start then. As I said, all questions we can keep them till the end, and we will get through those. Like I said, this iteration of the presentation is its third review now, so we have updated it slightly. I'm just going through the front of the slides now, just showing where NQA operate in the world. My slide does need updating a little bit more. We've been operating for around about 30 years now. As you can see, we work with some quite big multinational companies, a lot of whom use it 27001 already. But anyway, why we're here. Let's move on to why we're here. So what we're going to look at today is we're going to look at why and what is the GDPR. How will data be processed under the GDPR? We'll talk about data breaches as well, because that's the important part really, is what will happen if there's a data breach and the consequences of that. We'll look at how using ISO 27001 can help you gain compliance towards GDPR. And we'll look at how the GDPR, or how 27001 maps across the GDPR. Now, again, as with all the presentations I've delivered, I've always said this disclaimer is that while 27001 will go a long way to helping you gain compliance, it won't do it all for you. There will be certain elements that 27001 doesn't cover, and you shouldn't use 27001 as a tool to gain compliance to GDPR solely. There are other things you need to do, and we will discuss those later on in the presentation. A further warning, obviously GDPR goes live on the 25th of May this year. That's when GDPR will be fully enforceable. So that leaves us with 21 days to go. That's right. If you are listening to this webinar today on May the 4th, International Star Wars Day, you have 21 days from today. Obviously, if you're listening to it tomorrow or next day, that figure will come down. But May the 25th this month. So then, a bit of background then. Why GDPR? Why has GDPR been developed? Why has it been brought into law? Well, in today's ever-evolving digital environment, the protection of personal data has become more critical than ever. We've seen numerous news stories, some going back to last year with the NHS and the viruses they suffered, more to the Facebook scandal, which has broke more recently. So it's more critical than ever. Data breaches occur with greater frequency, and the cybersecurity standards that were put into law some 20 years ago, they're no longer enough to protect the information of businesses and customers that interact online. Now, the larger the database as well, obviously the graver the consequences of a breach for parties at both ends. As we've seen with the likes of Facebook, the databases they hold have affected millions of people worldwide. Now, the GDPR is intended to solve security issues that have emerged over the past 2 decades since the development of cloud technology, and also its impact on data security. The GDPR it was developed by the European Union over a 4-year period to serve as a legislative solution to issues regarding data protection in the present day. Now, currently, laws regarding data protection in the UK are based on the Data Protection Act of 1998. This was an update of the 1995 EU Data Protection Directive, which in itself was designed to handle security issues as understood by lawmakers and programming experts in the years leading up to the millennium. So as you can see, they are coming towards the end of their life now, and the issues have changed, technology's moved on, so the legislation behind those technologies has to move on as well. What's the purpose then? Now, the regulations are designed to protect customer data in a new digital environment. In an age where companies like Facebook, Google share the personal data of account holders in exchange for things like site access and features, GDPR seeks to return more control of this situation back to us, the user. The other reason for the GDPR is to establish a clear-cut set of regulations under which businesses can operate in regards to the handling of customer data. Now, with these new rules, the boundaries would be easy to understand on both the corporate and consumer end. It's going to make it easier for businesses to earn and hold the trust of customers. Now, the law also offers more power to citizens as well. It gives the power back to us in regards to what companies can do with our private data. The new law, it will be beneficial on both sides, but the GDPR has been designed to protect consumers. And as we can see there as well, this also includes business to business, business to consumer, and business to employee transactions as well. So the aim, as it says there, was to reduce or eliminate fears of online hackers. Now, these could be reduced, if not eliminated, by the new regulations. And with the laws on data protection becoming more clearly defined throughout the EU, the GDPR could save the European business economy roughly €2.3 billion a year, or 2.3 billion pounds a year. Sorry, that saving could in turn be passed on to consumers. Now, we will touch on what will happen in relation to Brexit and things like that as we go through this. So we're not just going to gloss over the Brexit issue. As we said, the law comes into force on the 25th of this month, and it remains to be seen just how immediate the new regulations will be implemented across the board. Despite the fact that most IT security professionals have acknowledged the scope of the GDPR, less than half of them have readied their systems for a new law. Now, obviously, as the time ticks by, a lot more people are doing a lot more to combat GDPR coming in force. No doubt you will have all had emails off different marketing companies telling you that they are updating their privacy policies and we need to find out what your preferences are so we can contact you. Again, this is all in line with them bringing their house in order in line with the GDPR. So, who does GDPR affect? Well, there's two parties in the realm of data security that are directly impacted by the implementation of the GDPR, and these are the controllers and processors of digital information. Now, as we can see there, according to Article 4 of the GDPR, different roles are identified as indicated there on the screen. We have controllers and we have processors. Now, a controller, now this is a statement taken straight from the Article 4. A controller means a natural or legal person, public authority, agency, or other body which, alone or jointly with others, determines the purposes and means for the processing of personal data. A processor, on the other hand, is a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. For example, a controller could be a bank, taking lots of personal data off us, the users, and they would control it and decide how that information is used. They can then pass that information onto a processor. If they have an IT support company, for example, who would process the information on behalf of the bank, the controller. Now, the organizations that determine the means of processing personal data are controllers, as we said, regardless of whether they directly collect the data from data subjects. As we said, a bank collects the data of its clients, when we open an account, but it's another organization that stores, digitizes, and catalogs all information produced on paper by the bank, such as the IT support company. Now, these companies can also be data centers or document management companies, but both organizations, the controller and the processor, are responsible for handling the personal data of these customers. Now, the data controller remains responsible for ensuring its processing complies with the GDPR, whether it processes in-house or engages a data processor. It is a controller's responsibility to determine how it monitors and evaluates the processors. Now, we had a question on a previous slide regarding that, and regarding how controllers can monitor processes, and we will come on to that later on, so we will get to that. Now, data processors face direct legal obligations under the GDPR in such areas as security and record keeping. Under the GDPR, controllers can only use processes providing sufficient guarantees to implement appropriate technical and organizational measures so that the processing meets the requirements of the GDPR and protection of the rights of the data subject. Now, if these processes breach the direct obligations, they can be fined by the supervisory authorities, which in this country at the minute is the Information Commissioner's Office, the ICO. And the supervisory authority can hold jointly liable with the controller for the entirety of any damage to a data subject, unless they can prove they're not in any way responsible for the event. So the controller has to show they have taken every steps possible to safeguard that customer data, that personal data. So when and who does the GDPR affect? Now, we're going to talk about the processing of the data. Now, according to Article 5 of the GDPR, the controller shall be responsible for and be able to demonstrate compliance with all the principles relating to processing of personal data. These principles are lawfulness, fairness and transparency, data minimization, accuracy, storage limitation and integrity, and confidentiality of personal data. Now, according to Article 28 from the GDPR, and I'll read this out verbatim, where processing is to be carried out on behalf of a controller, the controller shall use only processes providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of this regulation and ensure the protection of the rights of the data subject. So a controller is required by law to process EU user data for specific purposes with complete transparency. They have to tell people how they're going to control what they're going to do with their data, how long they're going to keep it for, things like that. According to Article 83 of GDPR, fines will be imposed regarding the degree of responsibility of the controller or processor, taking into account technical and organizational measures implemented by them. As we said before, if a controller can show he's done everything in his power to protect that personal data, and it's a fault of the processor by not sticking to their policies, procedures, then the fines will be dished out accordingly. So, lawful consent then. As we can see there, lawful consent is based on any one of those four things. Now, as soon as the GDPR is implemented in 21 days' time, controllers will be required under law to process EU user data for specific purposes with complete transparency, as we've just said. Now, the purpose, once the purpose is completed and the controlling processing entities have got no lawful need for data of a given user, the data must be deleted. Therefore, personal data will no longer be stored idly on servers, just sitting there waiting to be kind of hacked or stolen. Now, for the personal data of EU residents to be processed lawfully under the GDPR, at least one of the justifications mentioned on screen have to apply. The law is designed to put the interest of online users above the entities that could be intent on exploiting or sharing personal data. So as you can see there, there's four things. And you have to have a lawful consent to process data, and it can be one of those four things. Compliance with a legal contract, for example. If you sign a contract that you will do something, and you get consent by someone signing a contract, then there's one example. Now, for controllers to get the agreement of an individual, the person has to give consent, and it's got to be a direct confirmed action. Now, the pre-existing kind of standard of justification, which allows controllers to use data with only a passive acceptance on the part of the person, is not going to work under GDPR. Consent cannot be gained through means that would only be understood by users who pass over the fine print of a given set of terms. So no longer can it be something right at the bottom of the small print that says uncheck this box if you don't wish to be contacted, etc., etc. The consent has to be given, has to be a direct confirmed action, such as you typing your name into a box or ticking a certain box to say yes, I want to be contacted, things like that. Now, it's the controller's obligation to keep a record of the time, date, and means through which a person has given his or her consent, and to respect the individual's wish to withdraw at any time. So any business, charity, or government agency that doesn't currently conform to these new regs will have to bring their protocols into compliance by the 25th of this month. Many companies, the implementation of best practice standards has made this transition a whole lot easier. Now, we had a question last time about data rollback systems or backups. Data storage systems or backups or rollback systems, they have to be developed so as to protect data and maintain its privacy. Organizations may need to complete a legacy data audit to ensure that any personal data held by a processor or controller does so in line with GDPR. Now, this will enable organizations to identify where consent was granted correctly and delete records where consent was not or cannot be obtained. Such things I've seen is data mapping exercises and just seeing what data you are holding. It's actually quite a good housekeeping exercise, I think, because you do get rid of a lot of data that you don't really need. So moving on now to the kind of categories of personal data. Now, the category that constitutes private data within the EU has become a whole lot broader under GDPR in response to the type of information that companies now gather from individuals. Information about a user's computer and location, such as an IP address, is now considered private data. Other information, such as the financial, psychological, or ethnic history of an individual, would also be defined as personal information. Anything basically that can be used to identify an individual would qualify. Personal data is defined as anything that can identify a natural person, a living human, either indirectly or directly. And it can be anything such as a name, photo, email, address, which includes work email, by the way, bank details, medical information, biometric and genetic data, or like we said, even down to a computer's IP address. So we touched on consent now, and we'll move on to consent in a bit more detail now, and look around the right to be forgotten as well. Now, a person can request to see their private data at reasonable intervals. Now, this is defined by the GDPR. Now, under the new law, controllers will be obligated to respond to a user's request within 30 days. The new regulations, they also require controllers and processes to maintain policies of transparency regarding the means through which data is gathered. It's gathered, used, and processed. The language used to explain these processes must be worded in simple, clear layman's terms, and not littered with confusing jargon. You know, it can't read like a formal legal document. It's got to be clear so that anyone can understand it. Now, each individual is entitled to access any private data held by a company. Furthermore, each individual has got the right to know just how long his or her information will be stored, which parties will get to view it, and the reasons for which the data is being used. So as users, we have that right where we have a right to know where it's being stored, what it's being used for, and how long it's going to be used. Now, whenever possible, controllers will be encouraged to offer secure view and access for any account holder who wishes to see their personal information. People will also be able to request that incorrect or incomplete data is corrected at any time. Now, a person can request that their data is deleted at any time as well, so for any reason. And this is under the right to be forgotten clause. So if an individual feels that their data is no longer essential for the original purpose of its collection, such as when an address is collected to verify that a person meets the geographical requirements for taking part in a contest or survey, a request can be made to have the information removed from a database. So we can basically contact the company and say, you don't need my information anymore, can you please delete it? Now, when a request to be forgotten has been made, the controller is obligated to inform Google and other data gathering organizations, other search engines, things like that, to delete the data. And the risk of having dormant personal data leaked to third-party marketeers is going to be greatly minimized under this new law. The way that we can see how our data is used is via something called a subject access request. Now, we had a question previously, can companies charge for these subject access requests? Well, organizations can only charge if the subject access requests are instituted without sufficient grounds and serve only to cause annoyance to the organization. So if someone is just asking a company for these subject access requests every day and there's no real reason behind it, they're just doing it to kind of make a nuisance of themselves, then the organization could impose a fine, a charge, sorry. The GDPR allows companies to exceptionally charge an administrative fee for unfounded, excessive or repetitive requests. Organizations can also refuse to respond to a request, but you've got to be able to demonstrate that how the request is unfounded, excessive or repetitive. We also talked about, there was a question again last time about how long data can be stored for. Personal data, it can be stored for longer periods under GDPR, provided that personal data is processed solely for archiving purposes in a public interest, scientific or historical research purposes, or statistical purposes in accordance with Article 89, number 1. Now, this personal data must be stored by the appropriate technical and organizational measures in order to safeguard a data subject's rights and freedoms. The GDPR requires that data shall be kept for no longer than is necessary for the purposes for which the personal data are processed. And organizations have to identify what personal data they process and the reason for processing to determine retention periods that are appropriate for each type of record. For example, if you're keeping records of an employee for health and safety reasons, for health screening reasons, if they worked in a dusty environment, and you may need to keep records for a certain amount of time as part of a legal contract under health and safety law. If that company leaves your employment, you may still have a legal obligation to keep those records. So we'll look at breaches now and the kind of the business end of the GDPR. Now, any organisation that collects the private data of users is required to report news of a data breach to a protection authority. Now, this news must be reported, as it says there, within 72 hours of when the breach first becomes known to the organisation. Now, in the UK, the Information Commissioner's Office, the ICO, is that authority. Other countries, it will be different. Now, failure to notify a data protection authority within 72 hours could result in a fine of as much as 2% of a company's global annual revenue, or a fine of £10 million, whichever is the whichever happens to be a larger amount. Now, if you compare this to the current ICO fines, which only go as high as £500,000, the penalties under GDPR are far stricter. Now, the 72-hour deadline to report a breach will not only give an organisation enough time to learn the full nature of a particular offence, but it should provide sufficient time to gather adequate information through the authority about the kind of data that will be affected by said breach. Just as importantly, an organisation should be able to give a rough estimate of the number of people that was impacted by the breach, and this way, potentially affected parties have more time to react. So, excuse me, the 72 hours when they have to report to the ICO, they should have enough information to say what's been stolen or hacked, and who's been affected. Those are the kind of two main areas that they need to go back and contact the ICO. Now, you only have to notify the relevant authority, the ICO, of a breach where it's likely to result in a risk to the rights and freedoms of individuals. Now, if unaddressed, such a breach is likely to have a significant detrimental effect on individuals. For example, result in discrimination, damaged reputation, financial loss, loss of confidentiality, or any other significant economic or social disadvantage. Now, this has to be assessed on a case-by-case basis, though. For example, you need to notify the authority about a loss of customer details where a breach leaves individuals open to identity theft. On the other hand, the loss or inappropriate alteration of a staff telephone list, for example, might not normally meet this threshold. So, if an organisation fails to abide by the core principles of the GDPR, such as gaining consent, respecting the rights, obeying the requests of individuals, that organisation could face fines twice as high as those imposed for failure to report a data breach. So under the GDPR, the fine for failing to follow a new law could be as high as 4% of a company's global revenue, or a fine of £20 million, whichever happens to be a large amount. So this isn't about not informing the ICO now. This is just failing to follow a new law completely. You can see that the fines now are massive. They're huge. Now, Brexit. Now, until the UK actually withdraws from the EU, companies based in England, Scotland, and Wales will still have to be in full compliance with the new laws. British citizens, meanwhile, we'll still be protected under the GDPR until Brexit takes effect. And then once the UK is completed its exit from the EU, British companies will still be required to follow the new regs when handling the private data of EU citizens. So, when we leave the EU, the government may say, well, we'll take the GDPR on and incorporate it into our law, as they have done with certain other laws. But up until that point, and even after that point, any information we have regarding any EU citizens will still have to be handled under the new regulations. Now, compliance with the GDPR could be complicated at first for companies that haven't begun the process of updating systems to meet new regs. And obviously, I know we've got 21 days to go now, so if we haven't started just yet, we are leaving it a bit too close to the deadline. Now, this holds true for smaller companies, which might lack the infrastructure to complete the changes before the 25th of May. For small companies that are just beginning, or haven't yet started, which I don't know if there's any companies out there who haven't kind of looked at GDPR just yet. But for those companies, it will likely be best to hire a third-party entity such as a security or consultancy firm to help with the process of bringing systems into full compliance. Better yet, the adoption of best practice standards can contribute to ensuring that compliance is largely met in advance of any audits or assessments, such as 27001. Now, the party responsible for a data breach, be it an outside hacker, an inside rogue, or any other unidentified source, it won't matter under the GDPR because GDPR places full responsibility on the organisation itself. So for smaller businesses in particular, these policies and the fines will make compliance especially important. To that end, the early adoption of best practice standards, such as, again, 27001, although initially will be a cost to set up and a cost to maintain, but it's going to save smaller businesses a whole lot of money. Organisations that are already regulated under best practice models, like the FCA, will probably see a few changes under GDPR. Likewise, if a business is already certified with 27001, you're going to see a few changes necessary until once the regulations take effect. Now, there are a few things that we can do to prepare for GDPR, and the first one is assess and audit. Okay, so prepare for GDPR, ensure your organisation complies. You'll have to take stock of your existing processes regarding data. Now, conducting internal audits as well as bringing in outside auditors to review your procedures can help you get a clearer picture of where you are and where you need to be. You might also need to work with a cybersecurity expert if you need to improve your understanding of these technological issues. Okay, depending on the level of IT you have in your company, it may be best that you work with your IT department or your IT support company. The second thing, identify and locate personal data. Make sure you can find all the personal data you have. Document where it is located, who it belongs to, and who you share it with, and any other relevant information. Now, GDPR requires you to record all data processing activities, so make documentation a priority. Now, if you don't have sufficient knowledge about all your data, conduct an audit, find that information. Now, personal data, don't forget, it can come from customers, it can come from employees, it can come from volunteers or many other groups that work with your organisation. When you've identified and located that personal information, review your processes regarding the managing of data. Make sure you have a clear picture of all your policies and processes for how you handle personal data so that you can determine if they comply with the GDPR. Now, under the new rules, you can only process personal data if certain conditions are met for specific purposes, such as fulfilling a contract, amongst other things. Now, you're going to need to review the processes you use for managing data, how you get consent to process that data, the privacy notices you use, and also your kind of cyber / security procedures. Again, document it all. Show how you've reviewed your processes, things like that. Once you've done that, implement changes, okay, if you need to. Now, you will need to set up new procedures that comply with GDPR. Now, this process could take a substantial amount of time and effort if they're not already in line. Now, depending on the state of your existing data management policies, these tasks may include, but aren't limited to, the following, okay? So, updating privacy notices and consent management. Now, you may need to adjust your privacy notices, as you may have seen, with companies contacting you regarding privacy updates and getting you to re-sign consent forms. Now, you likely already use such notices, but if you do not contain all the information the new rules require, you'll need to update them. GDPR requires that they inform the user about how long you will keep the data, the reason you're processing it for, or as we've already discussed. So you need to that's where you need to be clear and transparent to the customer to tell them what things you're doing. Now, the regulations also makes changes to how organisations get consent to process data. Now, GDPR lays out more stringent requirements and emphasises that requests for consent must be clear and easy to understand. Data subjects, the people whose data you process, have certain rights under GDPR and can make particular data-related requests with which organisations have to comply. You might already have some of these processes in place. If you do, you should make sure they all meet the requirements. If you don't, you'll have to set up procedures for how to handle them. The new rules, they give users various rights of access. They specify information that you must provide people with when you process their data. And data subjects can also make various requests of data controllers under the new regulations. Now, upon a request from a data subject, the controller must also provide confirmation of whether their data has been processed. The subject can also request that you correct any inaccurate personal data, as we've already said, erase their data, and give them a copy of their data. This last right, known as data portability, also allows them to transfer that data to another controller. GDPR also includes various conditions to protect against data breaches, as we've already said. It also lays out reporting requirements for the data breach occurs. Now, this means you should have a system in place to determine if data was compromised, which should include identifying any vulnerabilities, monitoring access, and also detecting threats. You also need to put a plan in place, for informing the ICO, as well as any other affected EU citizens if a breach occurs. And you must send this out within 72 hours, as we've already discussed. Within that, you've also got to include information such as the likely consequences of the incident and the measures taken to address it. So what's happened, who's been affected, what you're doing about it, basically. Now, GDPR requires all data processing entities to track and record all of the data processing activities. So as we said, documentation is crucial for demonstrating compliance. So, when someone comes in and says, "How have you complied with this and that?" having a documentation to demonstrate compliance is brilliant. You can then sit down and say, "I've done X, Y, and Z," and there you go. You can see it. Another critical step of preparing for GDPR is assigning responsibilities for data management and other related tasks. And this ensures that they consistently get the necessary amount of attention. So for organizations whose core business involves data processing or who handle sensitive information, assigning those responsibilities will be a formal process. Now, GDPR directs them to appoint an official data protection officer, or DPO, who's got expertise relating to data privacy, data security, things like that. Now, not everyone will have to appoint a DPO. It could be someone's additional duty, for example, to be the data protection officer. Some companies, and it's laid out in the GDPR which companies they need to be, will have to appoint a DPO. And again, it's up to yourselves to kind of read those regs on roles and responsibilities and the data protection officer to consider whether you need to appoint someone as a DPO or not. Now, once you've got your data protection processes in place, it's time to implement them. Now, GDPR compliance, it won't be something you can just set and forget. You can't just set it up and go, bang, we're GDPR compliant. It's an ongoing process, an ongoing journey. You'll have to monitor your data systems and regularly perform audits to ensure everything is working correctly and identify areas for improvement. So you'll have to do things such as respond to requests from data subjects relating to things such as data erasure and a right to access. You'll have to control and monitor who has access to data and how it's processed. You'll have to watch for cybersecurity vulnerabilities and threats. React to any data breaches or other security issues. and document all data processes and compliance activities. Now, there's 4 things there we've mentioned, which some of you may think look a bit familiar, then, Chris. And you'd be right. They do look familiar. Now, when we talk about assessing and auditing, identifying, reviewing processes, implementing changes, those 4 things, what we're kind of it's nothing new. For those of you who have management systems already in place, you'll know that this isn't a new process, and here's why. PlanDoCheckAct. So as we can see, assess and audit, plan. This is when you plan in, right, what have we got, what do we need to do? Then you move on to do, identify. We move on to reviewing your processes, checking do they work, are they right for the company, are they sufficient? If they're not, we'll make some changes, we'll act, we'll implement those changes. Now we've seen this before with ISO standards, we've seen it, the PlanDoCheckAct cycle, as we said. That moves us on to 27001. Now, organisations around the world have studied GDPR, and they're likely aware that regulations are within the GDPR. You're encouraged to adopt best practice schemes. Now, ISO 27001, it's an information security standard that helps companies come into compliance with best practice models. Okay. Now, the standard covers 3 key components of data security. It covers people, processes, and technology. Now, when steps are taken to safeguard data with these 3 components in mind, businesses are better equipped to protect information, mitigate risks, and then rectify procedures that are deemed ineffective. As such, a growing consensus has emerged in the corporate sector that 27001 is the gold standard to use in best practice schemes. Now, by putting 27001 into effect, an organisation activates an information security management system that works within the business in question. Now, the standard is regularly updated and enhanced, and these ongoing improvements allow the ISMS to stay abreast of changes both within and outside the company, all the while spotting and eliminating new risks. Now, if you already achieve certification to 27001, you may have noticed some similarities between that standard and the GDPR. And again, like we spoke about, if you've already got 27001 in place, you will have seen that a lot of the things about data breaches, documentation of processes, things like that. They're all things that we talk about when we come and audit 27001. Now, 27001, it's designed to support the accessibility, confidentiality, and integrity of your information, and it helps you maintain legal compliance as well. It helps you protect your data from cyber crimes, from misuse, from fire, theft, and other threats as well. Now, having a certified ISMS in place gives your customers more confidence in your company, as well as improving your relationship with stakeholders and helps you mitigate risks. And like we said, there's 3 key areas that the GDPR addresses and 27001 address, and that's confidentiality, integrity, and availability. Now, a common example of confidentiality would be an online transaction conducted over secure methods, such as the use of encryption, whereby information is protected via security certificates such as HTTPS, banking transactions, things like that. Now, confidentiality it's ensuring that information is not made available or disclosed to unauthorized individuals, entities, or processes. So it's keeping that information secure that only the people who need to see it or have access to it. As for integrity, it's about safeguarding the accuracy and completeness of assets. Now, an example would be the trustworthiness of customer financial account information, i.e. bank accounts, personal information, held by a bank for conducting daily operational transactions. Sorry. Now, if these weren't correct, we'd be getting the wrong bills. Our finances would all look wrong. This is about the integrity of data, which obviously brings to the forefront again the issues in the news recently with, I think it's TSB Bank. They've had a lot of problems with people accessing their accounts just lately. And again, you can see integrity, availability, confidentiality, all those three things you could cover off with that issue. Availability, like we just said with the TSB thing, it's being accessible and usable upon demand by an authorized entity. So just as we've said in that example, people haven't been able to access their accounts, so bills haven't been paid, etc., etc. Now, as we've used a good example there, that it could pertain to a bank's customer-facing web service that hosts the online banking portal. Customers should be able to access it throughout the day. Obviously, in this example, they haven't been, so things have happened, and unfortunately, people have been quite badly affected by that. So, how does 27001 relate to GDPR? Well, we've got a number of things. The first one, data encryption. Now, it's encouraged by 27001 as the primary method to reduce the possibility of risks. Okay. In 27001, more than 100 controls are outlined for use, each of which can be implemented to lower the possibility of security risks. Now, with each control based on the result of a previous risk assessment, any organization that utilizes the standard can pinpoint the at-risk assets and apply necessary encryption. Next one, confidentiality, integrity, and availability of data. Yeah, we've just talked about that. Both 27001 and GDPR nod towards the confidentiality, integrity, and availability of data. Risk assessments. Now, according to 27001, an organization must enact complete evaluations of all possible vulnerabilities that could impact the company's data and to leave no stone unturned in the effort to safeguard the privacy, accessibility, and integrity of that information. We spoke about this. We spoke about assessing and auditing what information you've got, what are the threats to it. Now, at the same time, a company discourages the use of overbearing security protocols that could hinder a company's ability to operate effectively. So what we're saying there is keep your information secure off the back of your risk assessment, but don't make it too secure in that it becomes a hurdle to the operational processes within that organization. Now, both the GDPR and 27001 also address business continuity. Within 27001, the fundamentals of continuity in business management are laid out, and this is whereby controls are implemented to help a company keep information readily available in the event of a system interruption. For example, power cut, flood, fire, anything like that. Now, these same protocols can assist a business in its quick recovery from what might otherwise be a lengthy and costly shutdown. With the standard in place, companies experience little, if any, downtime, because you plan for them. If you've got a business continuity plan in place, which 27001 addresses and also is part of the GDPR now, if you've thought about what you'll do in a situation, then if that situation ever does occur, bang, you can put those processes in place and hopefully mitigate any downtime or recover from any downtime. Test and assessment. So an organization that gains ISO 27001 certification receives assessments and audits of its ISMS by a third-party certification firm, such as NQA. This ensures that the ISMS is compliant with the standard. Now, any company that implements the standard must keep its ISMS under constant review to ensure that it remains protective of private data. Now, we spoke about earlier, it's not just setting up a management system or being compliant with GDPR. Isn't just about setting it up and thinking, right, that's it, I'm done. It's a constant evolution of monitoring, evaluating, and improving. Compliance again, across both the GDPR and 27001. And according to Annex A control measure A18.1.1, this concerns the identification of applicable legislation and contractual requirements. Now, an organisation must list all legislative, regulatory and contractual requirements. If an organisation is required to comply with GDPR, then this must also be listed as one of the regulatory requirements. Now, even without the EU law, Control A18.1.4 in Annex A of 27001 leads organizations that utilize the standard through the process of enacting data protection. So we had a lot of questions where last time people asked, will there be a GDPR standard? Or will an update of 27001 be applicable to GDPR? Well, it already is in this respect, because it already says that you must find and identify the applicable legislation to your business. Now, for different businesses, this is different, but for all businesses now, GDPR should be right up there. It should be right up there, just as the Data Protection Act probably is now. This moves us on to breach notifications. As we said, breaches at a kind of pointy end of the GDPR. This is where it's going to hurt a company. Now, 27001 Control Measure A16.1, this ensures the efficient management of security incidents. Okay, it helps organizations come into compliance with the GDPR, under which authorities must be notified within 72 hours of a discovery of a data breach. Now, companies that have implemented the standard are faster to respond to such incidents, which makes compliance in this area easier to meet. Now, for those of you who already have 27001 in place, you'll know the need to have an information security, an incident management process in place where things such as breaches or anything like that, you have to report on, and then do your corrective action, your root cause analysis, and then what you're going to do to rectify that in the future. So for those of you who already do that off the back of 27001, you're not gonna kind of miss the 72-hour deadline of breaches, because it's something that you already do anyway. Finally, the next kind of topic, which both GDPR and 27001 cover, is asset management. Now, it's addressed in 27001 under Control Measure A.8, which includes personal data as an information security asset. Now, organizations that implement the standard, they're given an understanding of which types of data are essential, as well as where such data might be stored and for how long. Control Measure A8, it also covers the origin of personal data and the party that gets to access said data. Now, all of these are requirements of GDPR, as we said. Now, of course, the requirements of 27001 extend far beyond the principles, as mentioned earlier. Now, as an all-encompassing best practice standard, various other areas are also covered, such as methods that apply to staff training. The standard has been implemented by countless organizations throughout the world. With the frequency and consequences of today's data breaches, the standard has become an essential part of data security in a digital marketplace. Now, as we said before, is it enough? Now, 27001, it will take you a long way to becoming compliant with the GDPR, but it's not going to take you all the way. There are certain elements that you will have to cover off without 27001, such as, now, as we said, while some things are covered under the GDPR that are not, there are some things, under the GDPR that are not controlled under the ISO 27001 standard. Now, one of these things is the right of a data subject to have his or her data moved or deleted. The standard covers most of the requirements of the new law by virtue of the fact that private data is recognised as an information security asset under the standard. But as such, the standard and the new regs share like-minded views on data security. Now, essentially, any company that interacts with EU residents will need to reach compliance with GDPR. Okay. Now, because 27001 is considered far and wide the most secure of all the best practice standards, it will likely prove to be the most applicable standard under the new regulations. And already, more and more companies are swiftly implementing the standard in advance of the new laws. ISO 27001 is one of the most applicable standards for GDPR compliance. If the standard has already been implemented by a company, that company, you're already more than halfway prepared for the incoming regulations. Now, no matter where in the world the company is based outside the EU, that company will still need to be compliant with the GDPR as long as it gathers the personal data or sells goods or services to EU residents. This would apply to a company worldwide that collects money or information from people on the internet. So, for example, if you buy something off the internet and you're based in the EU, that company has to be compliant with GDPR, whether they're from America, Australia, anywhere. Now, organizations with 27001 certification, they're likely to meet many appropriate technical and administrative security requirements of GDPR, but many may need to make some adjustments. Article 42, number 1, of the GDPR provides that all member states, supervisory authorities, the board and the commission are to encourage the establishment of data protection certification mechanisms for the purposes of demonstrating compliance with GDPR. Basically, what they're saying is the use of best practice standards is a good use to establish compliance with GDPR. 27001, however, it's got a broader scope than GDPR in that it applies to a company's critical data as well as the personal data. Now, the standard can be used to protect personal data as well as any other data. GDPR also covers several areas that 27001 doesn't, such as the right to be forgotten, data portability, and also the right to be informed about your personal data. Now, 27001 doesn't explicitly address these rights, but an ISMS can support you in meeting these requirements. Because 27001 doesn't specifically include these rights, being certified to it doesn't necessarily ensure that you're also GDPR compliant. It will certainly support you in compliance and bring you closer to reaching your compliance goals. Now, because the two standards have some differences in what they cover, all 27001 certified companies impacted by GDPR should conduct a gap analysis. Now, this assessment, which NQA can perform, by the way, now it'll provide you information where you are now and where you need to change to comply with GDPR. It identifies all the gaps between your current systems and the ones you want to follow. As we said, you'll find that, and those companies I've been out and visited, a few of which I've seen have attended today, you'll find that a lot of the things that GDPR is asking you to do, you do as part of your as part of your 27001 certification anyway. So you know it's not as if you've got to kind of reinvent the wheel for this. You do a lot of it anyway. So if you have 27001 certification, it's just a few tweaks. There's a few things you might need to consider. But yeah, just go out there, assess your systems, see what you've got in place under 27001, or indeed if you need 27001 to help you step up to that mark. That brings us to the end of the webinar. Thanks for listening. I didn't see any questions pop up during the webinar, so if anyone's got any questions, please feel free to pop them in your box now, and I'll try and answer as many as I can. There's none coming through just yet. Again, what we've done in the past though is any questions that have come through which we've not been able to answer straight away, we put together a frequently asked questions blog. So we took all the questions we had from the presentation, we put them in a blog, and we put them on our website. The presentation itself, it's been recorded. It'll be on our YouTube channel. We'll also be emailing it out to people who've attended today as well. Even those, if you know people who registered but couldn't attend for whatever reason, they'll also get a copy of the recording too. So let's just see if we've got any questions. Okay. So I can't see any questions just yet, everyone. Again, please feel free to drop us some questions. We'll try and get back to you. Okay, we've just had some questions pop through just before we finish. So we've got one, and I think we touched on this towards the end of the presentation. Is 27001 going to be broadened to include the extra issues raised by the GDPR? At the minute, there's no call. I've not seen anything to say GDPR 27001 is due for being updated. I mean, it was issued in 2013, so it's getting quite old now. So it may well be in the coming years that they review it to see whether it can cover GDPR. The thing with the standard is, though, it already, as we touched on with the compliance section, is it already asks you to be compliant with GDPR under the identification of applicable legislation. So, they could say, well, we already kind of say that you need to be compliant with GDPR. Someone's asked, quick question related to marketing and sales from Michael. What impact will it have on acquiring new contacts for potential new customers? Well, again, as we said, when you're collecting data on new customers now, as long as you're transparent with them and tell them why you're collecting data, how are you going to store it, what you're going to store it, what you're going to process it for, how long you're going to keep it, etc., etc. As long as you're clear about those things, and you've got consent off people, that's what you need to do under GDPR. Another question regarding, would there be any more time after 25th of May, like a grace time to get our systems up to date with GDPR? Again, that's not really a question for me. I think you'd better off speaking to the ICO reference that, but just with any law, the law goes live on the 25th of May. So if you're in breach of the law come the 25th of May, you're in breach of the law. But again, I think that's something more for the ICO rather than myself. There are some more. Do data processing agreements need to be initiated by a processor or controller, or can it be either? Well, it does state that the data processing agreements have to be set out by the controller. Now, it doesn't mean to say they can't consult the processor to come up with an agreement, but it's the controller who stipulates how data will be processed. Now, if that's because they use a processor which was used in the past and they know all about their processing procedures and they're confident in them keeping them secure, that's fine. But it's ultimately comes down to the controller to say, this is how your data is going to be processed. This is how it's going to be secured. So that's all the only questions I can see at the minute. Like I said, we will get around to we'll take all the questions off if there's any more that I've not covered off there, and we'll put them in a blog, which will be up in the next few weeks. But the presentation itself, like we said, it will be emailed out to you within the coming days, probably next week sometime. So you'll be able to listen to it again if you choose. But in the meantime, thank you for your time. Thanks for listening, and I'll see you next time. Bye-bye.